I'm going to call the meeting of the Business Law Survey Commission for September 16th, 2025 order. I think we want to document who is actually here in person, the members that are here in person, and then virtually. So I believe we have, let's see, Mr. Gutmann here. There he is. Thank you.
Present.
Dr. Will. Okay. Mr. Montel. This looks like he's here. Mr. Enright is here. Mr. Miller is here. I believe Mr. Hollingsworth, Mr. Barrett, and Professor Sullivan is here. And then everybody else, I believe, is we have other people in the room that I think our secretary or Mr. Willis can put into the minutes. So let's move on to the minutes of July 15th, 2025. Does anybody have any additions or corrections to those minutes?
So moved.
Okay, is there a second? Second, Mr. Sullivan seconds. All in favor, say aye.
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 Any opposed? Okay, the minutes are approved. I will turn it over to the secretary for whatever updates he wants to offer.
Thank you, Mr. Chairman. Good afternoon, everyone. It is a pleasure to join you all here today. As you all know, I have not missed a meeting. I highlight this because I want to show my commitment to every division within the Secretary of State's office. Elections takes up the headlines when you read the news, but the Business Services Division interacts with so many Hoosiers every day in all 92 counties. So to all the members here, thank you for your continued work throughout our state. It is important that we have every single one of you here today and have a seat at the table. You can advise our office and the state on laws and rules that affect business formation. Your voices ensures Indiana maintains its ranking as one of the top states to start a business. As the Indiana General Assembly looks at the necessary and various boards of commissions throughout state government, I know this commission is invaluable. As Secretary of State, one of my top priorities is safeguarding Indiana's business climate. Our Business Services Division continues to fight filing fraud, and we're implementing updates to the InBiz portal system to meet the changes from House Bill 1593, which takes effect January 1st in 2026. Indiana is proud to be recognized nationally for taking proactive steps to stop fraudulent filings and protect entrepreneurs from bad actors who misuse stolen or fake identities. This was an important topic that was discussed during the recent National Association of Secretaries of State Summer Conference, where the Indiana Secretary of State's office and the Business Services Division was well represented. So this issue of business fraud and potential responses is not just an issue in Indiana, but we will work to be a leader in this area all across our country. We are also working to strengthen Indiana's ability to deal with deceptive commercial solicitations. Too often, companies mislead new business owners with confusion notices that look official, charging them unnecessary fees. Or worse, trying to get private information. Our updates will ensure better protection for Hoosier businesses. Our office also have experience with deceptive solicitations in other divisions, such as our securities divisions. And we have confidence that we will use what we already know to address those issues. I also want to welcome and congratulate the new members who are moving through the approval process to join this commission. I see Mario Masalamani, Matt, and Karina Sasueta here. Thank you for being here. I'm actually great to see you here in person, so thank you for attending. Your experience and perspective will add tremendous value, and for the first time in many years, we will soon reach full membership in this commission. So thank you for coming. Once again, ensuring this body's membership is full shows the commitment that I have to this division and this commission. The more voices we have, the better. And the more projects this body can complete and work on, it will benefit our state. As you can see, we have the high caliber of attorneys here in this room and in the commission. It speaks for itself, starting with our chairman and the Honorable Sullivan here. You know high caliber people, and I'm honored that you guys are a part of our commission. I'm out there every day promoting Indiana. Not only promoting our state, but promoting our businesses and ensuring each business knows they have a partner in the Secretary of State's office. My team and I are constantly attending groundbreaking ceremonies and ribbon cuttings across the state to allow us to foster that relationship with businesses. Just last week, I had the privilege of attending a groundbreaking for a new hotel in Greenfield, a sign of the continued growth and opportunity across our state. I will also emphasize the work we are doing with making sure businesses all over the world know Indiana is a top place to incorporate and start a business. I mentioned the National Association of Secretaries of State, our summer meeting that we had. I was there and I mentioned about regarding the business fraud hitting Indiana and all across the country. But also there was a great discussion on the role Secretaries of State play in international business development. States like Washington, as you all know, the National Association of Secretaries of State has a Foreign Affairs Committee, which I'm part of it. But states like Washington, North Carolina, Kentucky, Pennsylvania, and so many other states, they share about various trips they have taken all over the world. I want to ensure that Indiana is not left out and we stay ahead of other states in attracting businesses to our state. You may have seen there are potential changes in the horizon related to business certifications. And I've been focusing on small businesses and Indiana-based businesses. I want to highlight that in our community initiative that we kicked off at the beginning of this year is what it's all about. We want communities across our state to be able to give their local Indiana small businesses a platform so we can showcase them nationally. So we look forward to others seeing the importance of this program. And finally, let me emphasize that Indiana is always open for business. We welcome everyone here, and I hope everyone look for Indiana to invest and to continue to invest. Together, we are building a stronger, more secure, and more welcoming Indiana for businesses of every size. Again, thank you to each of you for your expertise and your commitment. I look forward to work ahead with all of you. Thank you, Mr. Chairman.
Thank you, Mr. Secretary. Let's turn now to Mr. Prentice and what he has to tell us about legislative support and some ideas for 2026.
Yes, thank you, Chairman. Just a few things regarding the Indiana Successor Liability Tax Act and those potential changes. I have turned those over to Jake German to identify a potential bill that would go in. We don't believe this will probably be a standalone bill. It will probably be within some other type of tax fiscal bill this legislative session. So our legislative counsel is Jake German with B&T. So he has all that information in the potential changes for the Indiana Successor Liability Tax Act. Some other changes we are looking for this legislative session. I've been working with our Business Services Director, Scott Willis. He has worked on some language about strengthening the deception commercial solicitation laws. So we have some draft language on that. I'll be working on that and identifying an author. I do believe that one will probably be a standalone bill. I just need to identify an author. And I'll go over some, I think I may need to leave a little early here, so I'll go over some other things regarding the UCC. I think Beth has found some documents from the past business service director about UCC updates. The Indiana code gives the office the unilateral ability to update UCC rules, and then we don't have to go through the regular rulemaking process. So we can go through the process, whatever process our office feels works. So we may have a few ideas. We'll probably run those draft rules by this body, make comments, suggestions. Obviously, we'll work off the model rules that are out there, and then make tweaks based on Indiana specific laws. And then new commission members, I will give a quick update on that. As of yesterday, I believe the governor's office has paperwork for all new members. So we are just waiting for their thumbs up and their appointment to the board. I know Scott Enright has already been appointed, and our other members, the governor's office has that paperwork in our letters of recommendation. So we're just waiting for their approval. I know Steve Carter did stop by our office this week for something else, so we brought that up to him. And they are working diligently on all their various boards and commissions they have to appoint people to. So we're on the list. It's just they have a lot of things to do. So that's all for me.
Okay, thank you. Mr. Willis.
Thank you, Chairman. As we've discussed a few times before with this group, and just for benefit of some of the new potential members, there's a lot of these deceptive filings that go out. We specifically target newly formed entities. It's a myriad of things, but it looks like it could be coming from us, and they're offering the great price of $400 to file a business entity report, which costs $30 and change. So it's really something that, you know, they've got all the earmarks of, you know, you need to do this right now. You could be administratively dissolved. It's just a lot of stuff that get people concerned that aren't in the process of managing their business on end business stuff. So they just don't know all the things that they're responsible for. And in many cases, they're offering things that are virtually free, either from our office or other offices, for significant fees. So we really want to try to shut this down. And as Mr. Prentice mentioned, he and I have been kind of looking at it. I think we're looking at just adding to section IC 24519 in the section that refers to applications of the chapter, and adding in some pretty stringent language on what these mailings can or cannot contain. We're following several other states that have put this in place. And as the secretary mentioned, as we go to some of these conferences and things and talk to the other states, it's pretty interesting. They'll get their law in place, and usually within a month or two, other states surrounding them see an uptick. So these folks just move to the next place. So I think the more of the states that can do this and share information about it in our systems and stuff, we can put some significant hurt on these folks that are not doing right by our businesses. And that I'll be glad to pass that along to this body as soon as we get it finalized for review. That's it for me, sir.
Okay, do you have something to add about the UCC update?
No, Mr. Prentice, you know, covered it. I think that we're gonna actually, I may discuss with Mr. Sullivan here a few things that to see what he thinks, and then as we kind of get it formulated, again, pass it by this body for the discussion. But we're really just looking to update the rules in place according to the IACA rules that have been published, and as he mentioned, you know, make any adjustments that are appropriate for Indiana statute versus those. And then we do want to push to try to mandate as much as we can online filing, because our paper filing, due to a few, I don't know, what would you call them? And I guess rent to own type companies and things like that, our paper filings are up significantly. And There are companies that could be filing online. They want to push the labor cost to us rather than them doing it themselves. This the way their things spit out of their system don't bode well to go into our system, even though they could do that through an XML process. It's typical stuff that we see before. We
Okay.
want to try to close that to, again, be more efficient with taxpayer dollars than doing it that way.
Okay, thank you. We can move to old business now. I think we've discussed already what's going on with our new commission candidates. So I think we're in process, and I'm hopeful that by the end of the year, we'll have a full complement of people that have been approved, and that will be great. We'll have a lot of folks that can tackle our aggressive agenda maybe for 2026. I think we sent out with the materials for this meeting the report of the task force on the changes to the Indiana Business Corporation law. And I think that you've all had a chance to take a look at that. I guess I'd like to turn it over to Mr. Gutwein to see if he's got any comments about what the task force did, and then we can talk about how we proceed from here.
Thank you, Chairman Becker. I feel a little bad, I guess, to start off with stealing any thunder that there is to be stolen from Mr. Hollingsworth. But I would like to, I guess, publicly thank, I guess they're not in the room, but Ben Manahan from Barnes and Thornburg, Uzair Farouk, and Brock Bucher from our firm, Jordan Spence from Bose. So they carried a large portion of the load. And I guess as we think about future commission members, these young lawyers at some point I think would be great additions. So that they carried the load in going through updates to the Model Business Corporation Act and the Delaware General Corporation Law, and making the review process for Josh and Joe and I, very, very easy. And then Ben Manahan did carry the load on drafting this memorandum that goes along with the proposed updates in these 4 areas, plus an additional statutory provision. So I don't need to belabor the point. I mean, there's a quality summary in that memorandum, and some updates in the statutes, but happy to I guess field any comments at this point. I guess my other question then, I guess for you, Chairman Becker, is would the process then be for us to turn this over to Legislative Services, or I guess what would be the next steps if the commission approves these updates?
Well, I think once we get everybody's comments and any changes that anybody has in this document, that we would turn it over to Legislative Services. In fact, we might even do that before we get approval. There is and I'm going to talk about this in a little bit some more, but there is a small hitch in approving this today. And that is that our operating rules require that 1/3 of the commission members be present in the room in order for any meeting to be, in addition to the quorum requirement, there's also this 1/3 present thing. And while I applaud the fact that all of our new members or to-be new members are here, most of them, they don't count, I don't think. And I would hate to get down this path and then have someone suggest that this was not a legal meeting for making this approval. So what my proposal would be that, and I don't know, Keegan, is there any advantage to turning this over to LSA now versus a month from now?
What is today, September 15th?
December
Yeah,
16th.
there would be no advantage between doing this now or a month from now.
Okay.
obviously you would just have the, let's say format that they always like to put this thing
Oh,
into,
sure, yeah.
which is easier to work off of,
Mhm.
than just, formats that we use. So, but outside of that, there's no advantage.
Okay, well, then my proposal would be, I guess, that today, if anybody has any particular comments or questions about the report of the task force, that we take that up today. And then that we try to schedule a meeting either for late October or early November, where we can do a few things here that we're not going to do today, and one of which would be actually putting our stamp of approval on this product and the proposed legislation. And so I guess my question would be, does anybody have any particular questions or comments they would like to make today? Questions for Stuart or anybody else on the commission or the committee if they're here?
I don't know if here counts since I'm not quote present.
Well, you're present, you're just not in the room present.
Present in the room. All right, fair enough. I did have a couple questions on this. Overall, I thought it was really well done. I thought the memo was incredibly helpful for context. On the shareholders' right to inspect and copy records, it wasn't clear to me what the meaningful difference is between the annual financial statements being available under subsection B1 versus under subsection 1E5. Because you can already get the financial statements.
That's a good question, Scott. I will have to take that back to our group. That is not a point that we discussed. We focused on the change of limiting the type of accounting records that were available under section B2.
Yeah, and I totally get that and the purpose behind it. It feels like we're giving the sleeves off our vest on this one. And I guess the next one that I had a question with was any agreement between a corporation and any shareholder. And that had me thinking about public companies in particular, but employment agreements and things like that. And was this designed to be within the scope of picking up somebody's employment agreement if they also happen to be a shareholder? Katie Couric is if she owns a share of, or whatever, she was the example years ago. But if she owns a share of CBS, does that mean that a shareholder is entitled to see her employment agreement?
We did not talk about employment agreements. I guess we did talk about in section D being able to impose confidentiality restrictions, which I suppose could include redacting sections as well, if an employment agreement was sought as and there's a proper purpose for it.
I guess part of me was wondering, well, what was the purpose behind covering agreements between a corporation and a shareholder? What was the thought process there?
Yeah, I think it was just so that there's transparency in related party agreements, and following Delaware and the Model Business Corporation Act a little closer in that respect.
And each of these are in Delaware and the Model Business Corporation Act.
I believe so. But I can verify that for
Yeah,
you.
it does align. I see in the memo, it aligns with recent revisions to Delaware. And I guess what I'm wondering is whether we say, agreements impacting governance, control, or distribution of corporate benefits, something like that, so that it just doesn't pick up employment agreements.
Sure.
Just a thought.
Yeah. Okay.
My only other, and I'm not sure what to, I made a note of this and I'm not sure what to do with it, but I seem to recall as we move into the exclusive jurisdiction provision, which, as Alan knows, is near and dear to my heart. I think that the SEC for publicly registered companies requires a carve out for Exchange Act and Securities Act actions. And I don't know enough. I remember that, but I don't know enough whether that is something that should be incorporated into this. I'm not sure it is, but I raised the question because this expressly permits a provision establishing exclusive jurisdiction for these things. And to the extent that the SEC says that some of these, if they're wrapped up in other matters, may not be able to be exclusive, then does that eviscerate this language? I'm just not positive about that. And maybe I'm making a mountain out of molehill.
Yeah, we did not discuss that. And we talked about Simon at length and that point did not come up. I can talk with Josh about that.
Okay. But otherwise, I'm 100% in favor of the changes that have been proposed.
Mr. Sullivan.
Following up on that point, I hadn't thought about this before, but you'll recall that our dissenters' rights statute has a carve out for publicly traded corporations, just as a general rule. And it might be worth Stuart thinking about whether that exception for publicly traded corporations would be appropriate for some of these other recommended disclosure changes. The theory would be slightly different. The theory supporting the dissenters' rights statute is that the market will price out whatever the value of the shares are. A dissenting shareholder doesn't need the litigation remedy. But the rationale for having a carve out for public traded companies on this inspection rights is that similar to what was just said, the SEC imposes significant disclosure obligations on publicly traded corporations anyway. And I don't think it's strictly a preemption analysis, but that ought be sufficient to protect shareholders without having additional statutory rights under the BCL.
Thanks, Justice Sullivan. I'll take that thought as well back to the group.
Yeah, I think that makes a lot of sense and would be a means of addressing the whole employment agreement issue too, because it's very different if it's an employment agreement in a small, closely held company versus an employment agreement for a publicly traded company. So that could be a really good fix all around.
A publicly traded company might still have to disclose an employment agreement, but it would be subject to federal securities law materiality standards.
Exactly, exactly.
Any other comments or questions? Hearing none, I would suggest then that Stuart will take some of this back to the to his task force, and he can report out, you know, by email between now and our next meeting, whether there are changes proposed or you know, some thoughts, people responses that they would like to make to some of these questions that have been raised. And if anybody else has other questions or comments when we actually come to approve this, of course, those will be welcome. Our experience with this is that until it gets introduced into the legislature, and sometimes even after it gets introduced in the legislature, changes can be made if people have, you know, good thoughts about things that need to be changed. So I would suggest that we bring this up then in our next meeting so that we can with the goal toward finally approving these changes with whatever alterations that the task force suggests or other people come up with between now and then. So that's all right with anybody? No objection. That's the way we will proceed. Mr. Sullivan, the LLC Act comments.
Mr. Chairman, the press of other business, which has been considerable, has kept me from making any progress on this, and I'll endeavor to have a report in advance of our next meeting.
Okay. It seems to me maybe that a realistic thought about this would be to try to see if we can do something in the first quarter of 2026 or thereabouts. I mean, I don't think that anybody is under illusions that we're going to work like crazy between now and the end of the year to get this done. So if we could, you know, if we could sort of target that, that would probably make some sense to do something like that.
I think that'd be right. As many of the people here know, there is a major piece of litigation that would affect this that's been pending at the Indiana Supreme Court for over a year now, and would affect what this says, and be interested to see whether the Indiana Supreme Court takes into account the recommendations of Mr. Gutwein and Mr. Hollingsworth in their amicus brief on this case. But I'd certainly expect the court, as long as that case has been pending, to wrap that, to hand down their decision yet this year, and that would dovetail with your first quarter of 26 target.
All right. I guess the question on the sales tax clearance process, is there anything further to say about that? It sounds like that's moving along.
I think Mr. Brent has covered the status.
Okay.
That we should hopefully know an author relatively soon.
Okay. My understanding is that that the Indiana Department of Revenue has indicated that they would be willing to submit something supporting or at least not opposing these changes to the extent that that was useful.
That's correct. Mr. Hoffman shared that at the last meeting.
Okay, good. So let's move on to new business and future projects. I guess we'll turn back to Professor Sullivan again to see whether what the ETA would be on the hub meta changes.
Mr. Chairman, the the hub and meta refer to provisions in our our business entity statutes generally that are derived from uniform acts promulgated by the Uniform Law Commission. And they have had underway a project to update those two statutes. And we've been awaiting their final report for over a year now. One possibility, I suppose, would be to just go ahead with the draft, which I think is probably substantially final. But again, given the press of other business, I sort of waited till they finished up their work product. But I'd be glad to undertake to press ahead, assuming that their final report will not be that much different than the most recent draft, which is now, as I say, over a year old. And but we would want to circulate this in such a way, the necessity for circulating this would be such that I think it would be very difficult to have any changes, which I don't think would be particularly material, but to have any changes in time for the next legislative session. Perhaps if they're minor enough and we're going ahead with changes to the BCL, maybe they could be folded into that. So why don't I circulate what is in the most recent draft, and we can see whether there's anything there that we think requires considered attention, or whether they're sufficiently ministerial that they could be folded in with the BCL project. Does that make sense?
Yes, I think that's fine. I think if you can circulate that, and we can make a judgment about whether if it's just little stuff, then yeah, we could include it in maybe in the BCL project. If not, then it can go on our list for 26 projects for the 27 session. As far as other projects in 2026, now that we are going to have lots of eager new blood on the commission, it seems to me that there are maybe 4 things that we could turn our attention to. And I am not assuming which ones may or may not rise to the level of being worth doing. They are all things that have been sitting around unchanged for quite some time. And I think that it would be great if people would give some thought to this. I mean, some of them at first blush seem obvious, but then when you think about it, you think, well, gee, nobody does anything with these anymore. But those would be the professional corporation statute, which now that we have tuned up the IBCL, I guess the question is, should there be anything done to the professional corporation statute? A second one would be the nonprofit statute. The third one would be HubMed, and we've already talked about that. And then the fourth one would be the general partnership and limited partnership statutes. We bring this up periodically, and it's obviously since the 1916 General Partnership Act, well, the one it's based on that, and the limited partnership statute, which was adopted back when I was an associate at Bose McKinney and Evans, which was long ago. There's been major changes in the structure of the uniform acts, and I guess the question number one is whether we like those kinds of changes or don't like those kinds of changes. But question number 2, which is probably equally important, is do enough people still form limited partnerships and general partnerships that it makes sense to spend our time and resources on that? Or is it just one of those things that can just sort of sit out there? And I mean, in theory, sure, it makes a lot of sense to have the most up-to-date statutes. But I guess it's more of a question of priorities, whether that's something that we ought to spend time on or not. And I mean, on the other hand, I mean, the general partnership statute is sort of the default. If you don't get around to filing anything with the Secretary of State's office, then you are a general partnership if there's more than one of you running a business. So there's something to be said for making sure that the statute is as up to date as it needs to be. But I guess I would be interested in people's views about whether that's something that we want to spend time thinking about, or whether that's something we want to drop to the bottom of the list. The other thing that I think probably ought to get a little bit of attention from us is something that has been around for a few years, and that is our operating rules. And as I mentioned, you know, that this issue that about 1/3 of the people being here in attendance, and then there's some other issues in there. I mean, those were adopted back when they were pre-COVID. They were back in the days before telecommunications was the way it is now. And even what you could do was sort of, nobody did it anyway. And so it was mostly talking about phone meetings. Now, you know, things are perhaps different. And I guess one of the questions I would have is whether it makes some sense to revisit those and determine whether there are a few little changes that need to be made here and there. I guess I would be interested in people's thoughts on that. And also, I guess I would turn to Jerry and ask whether he might be able to tell us at some point what other groups are doing in the government, other commissions and boards, or whether they have these, you know, 1/3 have to be in the room rules, and if you miss 2 meetings in a row, you're off the commission and all that kind of stuff. So
The other 2 groups that we work with, which was the Retirement Home Guarantee Fund Board, they have some pretty specific duties overseeing a fund and liabilities that might be associated with that. So it's sort of an accountability issue. The Motor Vehicle Sales Advisory Board primarily advises the Secretary and the Auto Dealer Service Division. They don't advise the General Assembly. They don't really focus much on legislation. So I think it's unique what Business Law Survey Commission does. I think there's opportunity to research that. I think that the governor's administration has some interest in looking at all the boards and commissions for relevance and for uniformity. So we could certainly look into that to see how they work. I recall, of course, we work with the official comments was a project that the commission spent a lot of time on, and then the legislative aspect, and then working with the Business Service Division, sort of helping them administer. So long way of saying I don't really know.
Okay, well, I guess probably all of us in the room could say, well, this would be the most efficient way to do this, but I'm also cognizant of the fact that there may be some sensitivity from the government side, that people are concerned that there's going to be folks that never make it into the room if we get rid of some of these requirements. And so I'm curious whether, you know, there's going to be pushback from anybody, you know, at the governor's office or elsewhere on this subject. Maybe they don't care, which is fine with us, you know, then we'll do what makes the most sense. But if there are concerns, I guess it would be good for us to know what those are. And I would think that might be something we want to take up in the first quarter of 2026 to just see whether we want to change the rules of the road a little bit here about how things get done.
Okay, we'll take a look at that and get back with you on that.
Okay, appreciate that.
I'm sorry, Mr. Chairman.
Yes, sir.
For those of us that are now thinking we should have known about these operating rules before we joined the commission, is there any way to send around a copy of these?
No,
Yeah, I'm sure that Mr. Willis could send around a copy of those to everybody.
Thank you.
Let's see what else we have to, is, I guess the last question here, the last issue is that this,
Mr. Chairman?
yes,
Would you mind if I just responded to your list of four?
sure,
quickly?
go right ahead.
I would say that, it might be helpful if we were to ask the staff if they could run some numbers for us on how many PC filings, we get, how many, LP filings we get. It would give us some, and how much, nonprofit corporation filings we get, just to give some idea of the volume of the business,
Sure.
in those, three areas. I do think updating the operating rules is something we definitely ought to do. We haven't done that since COVID. I think I've been here 13 years now, and I think we've done it since I've been here, but it was certainly pre-COVID. And the technology, I think, has just revolutionized all of that. You and I have had several discussions over the years about adopting more recent versions of the Uniform Partnership Act and the Uniform Limited Partnership Act. And I continue to be an advocate for doing that. The rules would only be prospective. They would only apply to newly formed general partnerships and limited partnerships. But I think over the years, they sort of reflect best practices. And I wouldn't be a bit surprised, but there are an awful lot of general partnerships and limited partnerships that are operating in Indiana right now, sort of don't even realize that they're not operating under current law. And as particularly as the big nationally integrated economy and all, really, if our new general partnerships and limited partnerships were operating under the rules that most other states are operating under, I think we'd all be better off. But just before I got here, I think it was probably about 15 years ago, the commission did a study of this. And the recommendation of that study was, yes, this would be a good thing for us to do, but it's not urgent.
Yeah.
And now 15 years have passed. So my presumption is that this is something that would be worth doing, but it will be interesting to see, given the primacy of the LLC, just whether people are forming limited partnerships much anymore at all. And that may cut against my argument, but I'd just like to be on record as saying that I think our state would be well served to have the most recent version of the Uniform Partnership Act and the Uniform Limited Partnership Act.
I tend to agree with you. The issue that I know was addressed in that study that was done 15 years ago or whenever was not that there was anything wrong with those new acts, but more that it was going to take some work to integrate them into the whole Indiana statutory scheme and make them similar to the other entity acts that we have. And I guess to me, it's mainly a question of whether we have someone who is fired up enough about these that they're prepared to lead a little task force to try to create something that would work in terms of turning the Uniform Act into something that could be adopted in Indiana. And so, if anybody is really excited to do that, I'm all for it, and I'm willing to say, I'm not going to stand up and say don't. So, I mean, I guess I think this is all the kind of discussion we need to have. And we can start it in our next meeting. And then if we want to continue it, in our first meeting in 2026 about exactly what we want to do. I think that the model that we used with the IBCL changes makes a lot of sense, which is rather than creating a committee of the whole that is going to spend all its time working on all these, that we put one or two people from the commission on a task force and recruit other folks that might be interested to come up with a product that we can then spend time and polish up the way we think ought to be, and then move ahead with that. So those are my thoughts. Does anybody else have anything else they'd like to add about that?
Thank you, Mr. Chairman.
Okay. I guess the other piece of new business, this is our annual meeting. And technically we're supposed to have officer elections for 2026. In view of the fact that there is at least an argument that this meeting is not legal because we don't have a third of the commissioners in the room present with us, I am inclined to table that sort of at the prerogative of the chair until our next meeting, our last meeting in 2025, so that we can have our elections then. At the moment, my understanding is, are you still interested in being the vice chair? Okay. And I guess Keaton, are you still interested in being the secretary? It's a demanding position, I know. Okay, and I'm willing to serve another year as chair. So I guess, but obviously the floor is open for other people who would be interested in serving on those positions, and we can plan to have elections at our next meeting so that we can get that piece of business done. I guess I need to ask here for public comments, if there are any members of the public here who would wish to do that. Hearing, yes.
Mr. Chairman, if I could, I'd like to make two observations. One is, and I don't think there's been any publicity about this locally, but our colleague, Mr. Barrett, has been placed on the leadership ladder of the Uniform Law Commission, our nation's premier law reform organization, the owner of the Uniform Commercial Code, the owner of the Uniform Partnership Act, the like that we're talking about. This is a significant professional honor and a significant recognition for him and for our state. And I'd like to see we're honored to have him as a member of our commission, and I'd like to have the minutes reflect our congratulations to him in this regard, and our offer to be of assistance to him if there is some way that we could do that going forward.
Okay, thank you. Anything else? Well, that's a great segue into the next question, which is the date for our next meeting, as well as Mr. Barrett has raised a concern that it would be very helpful for him if we had a set meeting schedule for 2026. And so the thought might be that we could, at our next meeting, see if we could figure out when we're going to have our meetings in 2026 so that everybody can put them on their calendars. And there's a greater likelihood then that, people can attend. And I guess the sort of related question is whether we still want to do meetings approximately every 2 months, or whether we would like to go to quarterly meetings. The commission has, the operating rules say at least quarterly. We've sort of bounced back and forth over the years between having quarterly meetings and having meetings every 2 months. And we can always have special meetings in between quarterly meetings if we decide to go that way. But I would be interested in people's thoughts about whether we want to do quarterly meetings or bi-monthly meetings, whether bi-monthly or whatever. I guess the immediate question that we need to address today is when we would like to set up a fourth quarter meeting. I would propose that in order to hit the deadline for submission of our IBCL changes, it probably needs to be either late October or early November. And so I don't know if we know what the secretary's availability is.
I do not
Okay,
have to find them. I would offer up as somebody that has been communicated by some of the members unable to attend, that if we could offer up at least 2 or 3 dates. So that
Okay.
they have some selectivity, that would be appropriate. And if you do decide to make changes to the rules, then maybe a way to go would be to have quarterly meetings and then a couple of set virtual meetings.
yeah,
That way you
Okay.
give folks that flexibility, where it is actually, and then you're able to modify the bylaws to still have those be legitimate.
okay. My proposal then would be that everybody should communicate with me dates in the last 2 weeks of October and the first week of November that you are not available. And then, and based on my experience with asking the members of the commission to communicate things to me, if you say nothing, we will assume you're available, or at least you waive your rights to object to the meeting date that gets selected. And then we will check on this end with the secretary, and then we will propose, a couple of dates and see which ones is the most popular. And then at that meeting, we will plan to address any further changes to the IBCL task force report and hopefully approve the proposed legislation for that. We will decide whether we're going to fold anything from HubMeta into that or not. And then we can discuss further anything we want to talk about for 2026 or anything else that happens to be, pressing business. And then try to set ourselves up for a big start in 2026. Any thoughts, questions, further ideas?
Mr. Chairman.
Yes,
Then CC me, I can compile that.
that would be fantastic. Please CC Mr. Willis on anything having to do with these dates. And if there's nothing further, I would entertain a motion to adjourn.
So moved.
Second,
Second.
all in favor, say aye. Aye. Okay, we are adjourned. Thank you all.
Thank you.
That you could be.